originalism has many different meanings. And when we talk about originalism, there's like 3 different schools of thought in the US, at least around this, something called New Originalism and original intent that's subjectively in the minds of people. And then there's kind of a revised originalism, but there are so many originalisms beyond that. And I want to suggest that it is a part of constitutional interpretation for good and ill. And it doesn't have a necessarily political orientation. It can be used by one side or another side more than others at certain periods in our history, but it's kind of apolitical, as it were, if you think about it in its broader perspectives. But I do want to suggest, and here's the other part of this thesis, that it has a priori commitments. And that's what I'm going to try to develop with you as we go through this lecture together, is what are some of those a priori commitments that are part of constitutional interpretation as we talk about many different originalisms. So my question is there an originalism underlying commitments to originalism? That is, if there's so many different originalisms, what lies behind that? Why are people so interested in trying to get to firstness or an a priori set of pre-existing understandings or foundational understandings? What's with that? And so in other words, what are the normative commitments underlying constitutional originalisms is a part of what I'm trying to develop with you here. So let's look at originalisms in context and recognize this isn't something that just happens in constitutionalism. This happens in many different interpretive traditions. So if you look at Genesis, obviously there's an originalism there, but within the account of Genesis, there's actually 2 different versions that are running around in Genesis as to what might be the firstness of that. And it's interesting to go through biblical interpretation and recognize that some people are very much about trying to find the pure words from the text that flowed from the most ancient sources. Others are quite happy to continue to reinterpret the text in light of contemporary understandings, even changing the translations of the text in relationship to our increased scholarship and study and understanding of wording. Likewise, the Quran, although it is in Arabic, has a sense of differentiation as to how closely people would look to the text and how much you might consider the words of the 4 after Muhammad comes along, and how you might think about the Hadith and their relationship to the Quran. And so there's a lot going on in that tradition. You know, if we think about scientific explanations of who we are and where we came from, we're constantly revising our text as we read the earth, as we read our genes and physics and thermodynamics to understand who we are and where we came from. Indigenous peoples have creation stories, originalisms, and their context that explains why they're here and tries to set some set of guiding principles as to how we should continue to live ourselves. And of course, we have originalisms or firstnists around Columbus and Cartier, Champlain, Simon Fraser. Sometimes people start the clock when these folks came along. And so originalism has a meaning that's related to a discovery, as it were, of North America. And then, of course, we have the constitutional moments of Confederation. As you know, there's not just 1867. There's so many different moments of Confederation that that's part of the way we might think through originalisms. So as we work through that understanding that that's a part of many different interpretative traditions, I want to ask, what is it about legal interpretation? Is there some metaphysics that might be in play as we're looking for this authority to guide our actions? And you know, one way of thinking about this is law is kind of a replacement for religious or natural law explanations. That is, constitutionalism is a replacement or actually replicates religion or natural law. And it fills the same ecological niche in our society right now that maybe Catholicism would have filled in 15th century France, or Islam would have filled at another time and place, or Indigenous law would have filled 500 years ago, say in a Cree community. And so if constitutionalism or law is a replicating or replacing doctrine, then we have to ask, who's interpreting? to who do we defer, priests, shamans, elders, ceremonial leaders. Are judges, professors, historians, lawyers, and clerks just a modern species of priests and elders and ceremonial leaders? And what are we interpreting? To who do we defer? Right? That idea of scripture and tradition is what I've been developing. Do constitutions, treaties, statutes, that they come in and fulfill that same kind of ecological niche, searching for authority, searching for that authentic firstness or purity that we might have been searching for in another time and place. Maybe not, right? This is a thesis question I'm proposing, and there's probably all sorts of different answers to that, but I think it's worth asking the question. Because if there are these origin stories in the law, we might consider whether or not there's a metaphysics attached to the law. That is, the law might give us messages about where we came from. That is, what are law's origins, which has then implications for why we are here. That is, what is law's purpose, and then where we are going. What does law prescribe for the future? Those are the big metaphysical questions. Why am I here? Where did I come from? Where am I going? Law might actually, and constitutionalism in particular, might be giving us some pathways for approaching those questions, and we might be taking them on implicitly. And I just want to make it more explicit, if that's the case, that this might be a part of the way we act. So the other question then that arises, and is just following along, what are Canada's origin stories? What is our sense of where did we come from? Or in other words, which originalism do we choose? If we're going to be creationists and look to a particular moment to try to figure out the big bang of the source of what we're doing, that then helps to explain that rest of the things that come along, I think it makes some difference to put our finger on, or at least point towards those originalisms that we could choose. And one of those, of course, is this notion of transplanted British imperialism or constitutionalism, which has embedded in it ideas of the doctrine of discovery, conquest, adverse possession, reception, given that there were other people already here and with ways of life and organizing their affairs. If British imperialism and constitutionalism is the trump for those that were previously there, is it one of these doctrines that really represents the original condition for how constitutionalism develops in this country? Or are we more based on a social contract, something like an agreement? And of course, there's different ways of framing agreement if we approach this from a treaty perspective. There are treaties that Indigenous peoples have between themselves and the natural world. Maybe that's the firstness. Maybe that's the originalism through which everything else should flow. Or maybe it's the treaties that occur between Indigenous peoples, treaties between, for instance, Haudenosaunee and the Anishinaabe, or the Mi'kmaq and the Passamaquoddy, or the Cree and the Blackfoot, or the Tlingit and the Haida. There could be something in that said that's our originalism. Or when the Crown comes along, there were all sorts of different treaties, peace and friendship treaties, pre-Confederation treaties, numbered treaties that went across the prairie. Of course, 25% of Canada has been taken up by treaties over the last 30 years in our land claims process that constitutionalizes treaties after they are negotiated and ratified in that process. Or do we have a kind of a social contract that recognizes and affirms pre-existing Indigenous rights and sees that they're continuing after the Crown's assertion of sovereignty and after contact? Could be another way of framing an originalism. Or we could regard these treaties as being about colonialism. That is, treaties really were just manipulating the Indians to get at their land and to get at their governments, to move them out of the way, to allow for the settlement of the country. And if that's how we consider our country to be founded, we need to own the exclusion that's a part of that. And then think about what does that mean for the contemporary ideas in terms of reparation or participation or whatever the case might be. Or maybe we can't decide what our origins are because they're all mingled together. Maybe the Constitution is everywhere and nowhere and cannot be pinpointed or adequately described. And if that's the case, doesn't that sound a little bit like some descriptions of God in some theological traditions that God is mysterious and is everywhere and nowhere. And so we really can't say what those origins are. We just get on with what we need to do today in this non-linear fashion that doesn't have a kind of an opportunity to be firm or certain about those sorts of origins. Now we can think about originalisms in constitutional contexts, and we have to ask, what is a constitution? Anishinaabe people would describe a constitution as Chinaknagay, which means a guided way of decision making. So should we choose Anishinaabe constitutionalism that was here before the arrival of European constitutionalism? Whose constitutionalism should count there? Or should we sort of think about constitutions as noun-based, that is classification-oriented, divisions of powers, rights and freedoms, checks and balances, separation of powers, and then put things into categories like that and then reason from categorization. Or maybe and, doesn't necessarily just have to be and, or sorry, it could be or, which is constitutions are verb-based. That is, we're talking about constituting continually, or how we constituted. And if we think about constitutions as conjugation-oriented, if you speak in verbs, that's a very different way of framing the world than speaking in nouns. And Anishinaabe, Algonquian languages that stretch from the East Coast to the Rocky Mountains are verb-oriented. 80% of the language is about verbs. It's organizing law, other relationalities by their conjugations as opposed to their classifications. And why would we choose texts as the place of originalism if we were in these different worlds that we've been talking about? And if we do choose texts, even if we do that, what is the role of texts in determining the Constitution's meaning? Our preamble to the Constitution Act 1867 says that Canada's Constitution is similar in principle to that of Great Britain, which means that our Constitution is unwritten, right? That textual preference has to explain the continued existence of the unwritten and wrestle with the interrelationship between the textual and the unwritten, as the court did in the Quebec secession reference, where they said many of our most important constitutional commitments are unwritten commitments. Canada's Constitution largely could also rely on unwritten Indigenous constitutionalism if we accept that firstness as a part of the way that we've come together that might not be fully accommodated in a textual statement right now, notwithstanding sections 35(1) of the Constitution that says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And then, of course, we also wrestle with the idea that there are many constitutional texts. Right? Section 52(2) of the Constitution Act 1982 says the Constitution includes, and then it names 30 acts in a schedule. That admitted PI and British Columbia and Manitoba and the Natural Resources Transfer Agreement. And that's just an including. That schedule itself might not necessarily exhaust what is textually a part of our Constitution. And so there's many time periods that we have to take account of when we're thinking about textualism in constitutional context in Canada, working through originalisms. So there are varieties of originalisms that people take when they're approaching the text, and this often is the question, does the Constitution have an objectively discernible or expected public meaning when something was drafted? And we have to figure out what that something is. Is it 1867? Is it the Royal Proclamation of 1763? Is it the Manitoba Act of 1871? Does the Constitution have an objectively discernible or expected public meaning when it's drafted, when it's debated, when it's ratified, when it's adopted? And then sometimes people want to give deference to textualism in this instance because they say that the Constitution is a product of a political agreement, which is probably true. There is an aspect of agreement there, but what if there's also disagreement? My colleague Jeremy Weber talks about the Constitution as being agonistic, that there are things that weren't agreed to, that people left in place and just papered over and tried to hunt down the road for another point where they might come to that. That is also a part of the text, and the meaning of the text is the agonism, that is the agreeing to disagree that might be found there. What about this point? What if the Constitution also reflects political domination, the text? That is a decision not to engage Indigenous peoples and settle and govern their lands without their participation. What if the text itself inscribes political domination, particularly when the texts are not democratically justifiable in relationship to pre-existing and continuing Indigenous legal orders, because we were just held out from that possibility there. Now, there is this section of the Constitution, as I mentioned, that talks about Aboriginal and treaty rights, which I've said gives a kind of species of originalism, which is called ab-originalism. And these originalisms that Aboriginal peoples are subject to under Canada's textual points, under its interpretive way of operation, can harm or help Indigenous peoples. Now, I think at present, the way originalisms function on balance hurts Indigenous peoples, but I want to acknowledge that, if you think about Indigenous peoples being here first, it could affirm and recognize the original governance and ownership of Canada. That is, if the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada, what is existing are those things that were there and have a continuity before contact, before assertions of sovereignty, then originalism is great for Indigenous peoples because it puts them first in line in relationship to the other possibilities that we have if we're fixated on this a priori way of operating. But it's also possible, and this is why I put this out here, that it could entrench colonialism and past discriminatory actions and make those discriminatory actions presently picked up in each generation. I've already mentioned this idea of the doctrine of discovery or terra nullius conquest, just assuming that this land was empty of law, empty of governance, or that the people that had law and governance were so low on the scale of social organization that their law and governance couldn't be incorporated or be chosen to be the leading guiding principles, and so they were pushed aside. As I mentioned, Indigenous people didn't participate strongly in textual creation, although that could be argued that the Manitoba Act saw the creation of Métis people participate in that textual creation because of their actions with the Riel Rebellion and the provisional government and the negotiation in Ottawa that set some of those terms of that provinces entering into Confederation, that dealt with language issues and dealt with a land base for the Métis people. And then there's this test that's come along from the Supreme Court of Canada in 1996, called the Integral to Distinctive Culture Test, in the case called Vanderpeet. That is, Indigenous peoples can claim rights if those rights were integral to their distinctive culture prior to the arrival of Europeans, right? Which is an originalism. It's an ab-originalism. And so the whole sort of law in this area is to try to figure out if Indigenous peoples were doing particular things prior to European contact or assertions of sovereignty. And if that's the case, great. But if the things that they do are solely in response to Europeans coming along, they cannot claim those as rights. So originalism is frozen at a moment of contact or the assertion of sovereignty. Now, that might be a broad originalism if you construe integral to distinctive culture widely, but it's been narrowly construed so far, in my view, by the Supreme Court of Canada in cases like Vanderpeet and Pamajuan. Then in the treaty context, what you search for is in the text a common intention which best reconciles the interests of the party. So you work out the meaning of treaties in the Marshall cases, 1999, and this goes way back to the Marshall cases from Chief Justice Marshall in the 1830s in the United States of America, where you're trying to figure out the meaning of the treaty by looking at how they interact with one another, what they put down on the text. And of course, there's another view of this, which is if you don't put it down on the text, whatever is not said is reserved to the people that already had it. Meaning treaties are a grant of rights from the Indians to the Crown. And if they don't grant those rights to the Crown, you can't assume that everything is in the treaty. They still might be in those original possessions that Indigenous peoples would have before they gave them up, potentially, or shared them, or whatever the case might be, through a treaty. Now, what about Indigenous peoples' originalisms? So I'm just suggesting here that it's not only Canadian constitutional law that has originalism, just like I said that the Bible and Quran and evolution, I might also have originalisms. Indigenous peoples can pick up on blood and family and kin and elders and language and lifestyle and skin, coloring or marking or heredity, or this pre-existing sovereignty, and say we have a right to establish law on the basis of these factors. And I think you might find some of these things incongruent with what our aspirations are in contemporary Canada, to found societies on blood, or just a single language, or a set of skin evaluations, or heredity, or the case might be. And so I question Indigenous peoples' originalisms as much as I'm trying to question here our Canadian constitutional originalisms, because I'm not always sure that a priori reasoning or practice should be normatively the point that we would take off on in putting together our contemporary constitutionalisms. I prefer the verb, obviously. But as I introduce this point, I want to just put the shoe on the other foot for a second and ask, might it be the case that Canadian originalisms reproduce many of these same effects for dominant non-Indigenous and ethnicities? That is, might actually our Constitution really be about a certain group's blood, or skin color, or hereditary opportunities, or sovereignty, or language, or sort of the kin and family structures of, say, European, French or English folks, be the originalism that really explains a lot of our Constitution. And so the text and these other things are just a way to try to replicate those other originalisms that I'm not so happy about, that I also see are articulated in Indigenous peoples' originalisms, that might be just on the ground the effect of our originalisms. Even if we just draw Indigenous peoples out of this, say maybe Canada's Constitution is really based on blood and language and skin color and heredity and French and English sovereignty. It's one of the implications that might flow from this. Now, is textualism a way out of this sense of law as metaphysics as I'm introducing it? That is, could we turn to positivism, this crowdsourcing teleology that tries to find a setting of a moment which we will all take guidance from by passing a law, a constitution. And so if we think about positivism in that light, we have to understand, at least in the dominant ways of reasoning, that the existence and content of law in these positivistic textual moments depends entirely on the institutional forms. That is, was it duly passed by a majority in Parliament? And there's no necessary connection between a law that's institutionally verifiable as coming from a majority in Parliament, either the British Parliament that set up our Constitution in 1867, or the in 1982, which was more a product of at least some, not Quebec, but some provinces' participation. There doesn't necessarily have to be a connection between law and morality when we approach textualism, which of course is its own kind of metaphysics, that you would separate that out and rely on the institutional, procedural dimensions of law to give us the authority, the deference, the requirements for what would be considered constitutional in that setting? Or is there something about a natural law selection here, that is, Indigenous law is just replaced by European textual commitments because that's kind of the law of the fittest, the survival of the fittest, like deal with it. We're here, we've got this, you aren't a part of this. Maybe we'll try in future documents to encourage and put into place other moments of participation, but it always has to be against the backdrop of someone else occupying that legal ecological niche and claiming that as their own, with their textual flag planted in the soil of discovery about that instance. So textualism might be the one way out, because all we need to do in that situation is to say, well, the Parliament said it, and if the Parliament said it and it's there in that way, then what choice do we have except amendment, to go back and amend that? Until there's an amendment, we need to leave it be and live with that immorality that might be present in that law as we go along. And some people say, no, that's not right. And so they say, let's do rights. Let's find rights as a way to check, balance, create a conversation that would push back against perhaps some of the worst excesses of textualism, but I want to wonder with you, as Ben Berger has done at Osgoode Hall Law School, whether or not rights themselves kind of play into this originalism as either a genesis. So this is quoting from Exodus 20, and rights spake all these words, saying, I am thy rights, thy a priori form, which brought thee out of the house of the pre-societal state of nature, out of the house of bondage. Thou shalt have no other a priori forms before me. Thou shalt not make unto thee any other a preeminent or a priori forms. You get the point, right? If you just take out the word God and put an a priori form in here, which is a right, the rights might be the things that are considered universal, a priori, fundamental, essential, first in our attempts to get at reasoning. And I have a colleague, Ben Berger, when I was developing these ideas, that said to me, he wondered sometimes if rights might act as savior. That is, our rights, which art in charters. Hallowed be thy claims. Thy kingdom come, thy will be done on earth as it is in theory. So some people posit textualism or rights as a possible way out of some of the metaphysical quandaries that we have with law. And maybe that's the case. I'm in a conversation about this, but I want to say that we would then have to ask ourselves, what are these originalisms among isms, and where do we stand? Where do I stand? Am I sectarian in this? Am I taking a particular political point of view or a particular interpretive point of view? Or am I ecumenical, meaning I can see that interpretive point of view, I can understand that, and I can find maybe some way that I'll be influenced by that, but I'll still keep my own faith in my own interpretive position that I have here, my own political commitment, whatever it might be. Or am I more agnostic, that I don't know? Or am I agonistic, that is all of the above, and everything is continually in operation in terms of these different streams being a part of that? Is, it's just really impossible to choose one as being first at all times and in all places. Maybe in particular contexts, there'll be arguments for choosing some firstness over other firstness, but not as a universal principle, which poses the question, is Canada's constitution itself sectarian or ecumenical or agnostic or agonistic, as the case might be? So here we are. Think about creationism. Think about originalisms as a prioricity. And so the question is, do originalisms rest on a kind of an essentialism, a fundamentalism, an a priori, a firstness, almost a Platonic form, a Kantian first principle? Is it even possible to think about law not doing this? Can we avoid replicating appeals to firstness? Maybe it's necessary in the way that we reason as human beings, that we need something in that regard. Or can constitutional law be idle, just kind of sit there? Or sometimes might it become an idol? That is, we kind of worship it, that it, as I'm mentioning earlier, it kind of fills the role of deference in our society to God that to law that to God might have been in another instance. And I don't know if we can even discern these normative commitments to originalism in constitutional law, although lots of people are writing about that. And where does human agency lie here? How does constitutionalism, creationism constrain or enhance human agencies? Should we recognize we're not innocent? Right? Adam, I hid myself in the garden because I was naked. He tried to claim innocence, yet was involved actively in doing something. Or here's the Sparrow case. Justice Dixon saying there was from the outset never any doubt that sovereignty and legislative power, and indeed underlying title of such lands, vested in the crown. The point is, we might have to think through what our own complicity is with a particular version of originalism, even if we don't want to face this or work through it. Because I like this Rush song, if you choose not to decide, you still have made a choice. Just picking up the tools and using them is a choice of ourselves, even if it's not fully understood. My own scholarship has tried to look at law having many sources. I want to respect and uphold so much of what occurs in parliaments and legislatures and courts that's helped along by lawyers and judges, but also to say law is more than that. Law, you can also think about it functionally, not just institutionally. Its standards, principles, criteria, authorities, measures, signposts, guideposts, procedures, criteria for making decisions, regulating affairs, and resolving our disputes. We have a whole constitutional framework that tries to build on this idea of intersocietal, sui generis, reconciliation, putting things together across legal cultures. We have constitutional traditions of these treaties being created over 250 years ago that try to put together this idea of law, not just institutionally, but functionally, to create criteria for decision-making that would be renewed on a yearly basis. And then I have these books that try to think about originalisms. The thesis of this one is it kind of depends on the context that you're examining. And the thesis of this one is that even if we get the text right, you still need people to come behind the text to live a law in light of other sets of normative commitments. And so that's why I'm asking about other originalisms behind originalisms. So originalisms, beware the danger of a single story. I know I talked really quickly there, but I look forward to any questions, comments, ideas that you have, as we've got about 20 minutes left here to share with one another.
Okay, well, thank you for that, Professor Burrows. Really gave us a lot of food for thought. I expect that there will be questions after that. Does anyone want to start us off? You can ask a question via the chat, or you can, pipe up via video, and feel free to ask your question that way. Any questions?
Perhaps that was a function of speaking too quickly, but I see Daniel here's got a question.
So somebody has a question. Yes, go ahead.
Daniel, why don't you give us your question?
Yes, I was just going to ask. I've been reading Weber's book, and he talks about the the difficulty with talking about support, or talking about agreement, right? Consent. Do we want to speak about that a little bit, or what portion has to do with originalism?
Yeah, that's right. So Jeremy's work wants to take Hobbes' insight that there's disagreement between human beings, and so therefore you need something to deal with that disagreement. And of course, what Hobbes proposed was the Leviathan, the creation of an overarching power that would provide reference for the rest of the decisions that we would make, because we couldn't otherwise agree unless we had this intervening Leviathan-like structure of law, in this case trying to justify British constitutionalism. Jeremy wants to reject the idea that you necessarily need an agreement to found a law. So he doesn't go on a Lockean way, a line that we need a social contract. He just says disagreement is always a part of the law and is there as the initial condition of law, disagreement, and therefore should be continually grappled with in every subsequent issue that we might find ourselves in. And we might have moments of contingent agreement that sometimes could be quite broad in scope, but we must recognize that that contingency is only as valuable as our ability to persuade people in the moment in relationship to the different authorities that they might have reference to, before we then run off in 10 different directions and interpret what that agreement was in very different lights, given our political affiliations, our religious commitments, whatever our identities might be. And so he would say that even in the moment of agreement, there's likely differential points of view about what that agreement means. And so he would just continue to see that agonism that proceeds along in our constitutionalism as a condition of law, as opposed to agreement or social contract or textualism. Anna, and then Eric.
Hi. So yeah, first off, thank you for the welcome, and it's so great to see you again, and a couple other names that I recognize as well. Sorry, I'm in the car if you can't hear me, but first off, this is just incredible as always. And as a partial, United States citizen here, where I remember when I was at University of Victoria, there's a lot of kind of disdain, I guess, for the American originalism that is very common. That Scalia and many of our other Supreme Court justices talk about as this like ideal theory of interpretation. And so I'm curious. You talk about many different originalisms, and it not necessarily being political, but in the U.S., I feel like it tends to be highly politicized, or at least a legitimizing tool or theory through which different political parties kind of operate their own agendas. So I'm kind of curious if you think that common in Canada or the differences between the U.S. and originalism. So, thanks.
Okay, so that's a great point. And it is the case that any interpretive tradition can be captured by a particular group and used to try to build an agenda that would prefer their interests, or say that this is the best way of adjudicating between interests. And so there, that can definitely happen. But it doesn't necessarily just have to be one group that could do that. And what I find interesting about originalism in U.S. constitutional interpretation is that it's kind of a shapeshifter. It's itself a trickster figure, where it had a kind of one personality in the 1970s, and then developed another kind of originalism in the late 90s, and now in the last kind of 3 or 4 years, there's another kind of originalism where you make a distinction between interpretation and construction in order to understand originalism. So it's interesting that originalism itself as an interpretive method is fluid, that it's hard to grapple with originalism as an original. Like, there's no original position on originalism, as it were. And maybe people think, well, the newest edition that we've got, that's the one that's should have been the first one, because that's the best firstness that we've got. That's the best a priori way of proceeding. But I wouldn't be surprised if 5-10 years, there's another version of originalism that comes on that nuances what we've already got. And so be it. That, I think, is what's happening. And I admire US constitutionalism for that, because that's a creative process of innovation that allows for human agency. We might be concerned that one political view captures that and doesn't necessarily allow certain distribution of other ways of proceeding in that. But I admire an interpretive idea that has fluidity as a part of it, that can also strive to question its firstness. Because remember, the original firstness was, well, you got to get inside the subjective intent of the framers. And then people realized, well, you can't do that. First of all, you can't get inside anyone's mind. And then secondly, there were so many different minds from so many different states. And then there was so many different minds when you're in the ratification. So we had to move beyond that. So anyways, I just really appreciate the question. Hopefully that's a bit of reflection on that context. Eric.
Hi, first of all, thanks very much for the talk. It was fascinating. I don't think we've ever met. I'm a professor at the University of Moncton, Faculty of Law. I was wondering how you think about the relationship between, I guess, what you might call the empirical questions of, say, political sociology versus the types of normative questions you were raising in your talk. I couldn't help thinking while you were speaking about Carl Schmitt's notion of the true constitution of a state being this kind of condition of political order that precedes the existence of any sort of positive legal constitution, and from which that text, if there is a text, would derive its authority. And that obviously is an empirical or a factual question as to whether or not such an order exists, and whether or not there is a body or bodies that are empowered to create binding norms or institutions. And it seems to me there's a bit of tension there with some of the ideas you were developing in the sense that, it seems that we need something to the extent that we all agree that we're engaged in a common conversation, we need some explanation of how we got to that point in the first place. And I guess I'm just wondering if you could maybe elaborate a little bit more on that.
Yeah, that's a great question. And I suppose my explanation as to how we got to that place would be to be aware of the danger of a single story and understand that different people have different explanations as to why we're here having this conversation, what the background conditions might be, whether or not they can be remade, whether or not we've come to agreement around certain things. And that's a very unsatisfactory position to occupy, I realize, to say my politics is it depends. You can't rally a political party around that. It's hard to go stand on a blockade and say, well, it depends. But I do make the point that I'm wanting to enhance human agency as much as possible and find ways that we can be participants with one another in figuring out which conversations we're having and when and how and where they stem from and what the constraints or opportunities might be within those conversations. Because I ultimately see law as something that we do. It's a verb, right? It's not just a noun. We should be lawing, and to law is different than to say, here's an expert with a specialty that will come and do this thing to you, and we must. I mean, there's a certain human agency in that if you're going to be deferential and obedient because you're, persuaded by the system that's in place. But there might be more that we would also engage beyond this, which is to not throw out the baby with the bathwater, saying, we need to keep talking with one another, but to insist that I must listen to you or talk to you, or you must listen to me and talk to me on the basis of my worldview, my prior commitments. I guess that's my quandary, and I'm owning that. It depends way of thinking through constitutionalism.
Thank you.
Thank you. Any other questions? Oh, we got some here.
Stefan?
Yeah, go ahead.
Oh, can't quite hear you there. I know you're unmuted.
This headset has been giving me trouble today. Is that
Sure.
better?
That is better.
We can
Thank
hear
you.
you now. Yeah.
Okay, super. So my question for you is, as somebody who's not exactly an originalist, and who mostly works on common law issues, I know you know the discussion we had at the beginning of this sort of originalism that's more, I guess, in a sense, more like a customary idea. Is this something that, in your view, is the fact that we try to move away from this? Is it a product of essentially legislation? Is there anything? I guess my question is more on this sort of if we move away from a statutory paradigm, does that sort of thing stop making sense?
Okay.
Sorry, the question is.
No, that's good. So I have a hard time categorizing myself. I'm not sure if I'm advocating, but I am trying to say that legislation is important. Textualism is important. We want to understand what's there in 1867, 1982. We want to understand what's there in the statutes. But I'm also saying that let's just not stop there. There's so much other work that we have to do in developing customs of people that would be more loving, kind, honest, respectful. There might be things that we can do in a mode of engagement, puts people into community. So the kind of the clinical legal education model where we become an observer participant in the stuff that we're doing. I'm not taking a textualism off the table by any means, but I just want to put it into conversation and therefore qualify it by seeing that there's so many other things we could be doing as lawyers or lawyers to be. And I feel like we're missing that, where people are tweeting across vast divides in further dichotomies without engaging a sense of, so who are you and what are your complexities and what is going to be helpful, hurtful. I worry about law that just becomes a dictate or an abstraction that doesn't live. And I suppose that comes from being involved in Indigenous law for many years, where that is something that does try to prioritize putting the law inside you and having you act in a certain way as a result of those commitments. Thanks, Stefan. Joshua?
Hey, John. I'm just curious, do the Canadian courts and the Supreme Court, and the Supreme Court in particular, like, do they often engage in reflections on their positions of which originalisms they're ascribing to? And is there even space for them to do so and to choose to adopt different originalisms that are less problematic, for example, when Indigenous communities are involved in cases?
Yeah. So the Supreme Court has practiced originalism for a long, long time. It's part of our interpretive traditions. And they've not done a good job of being explicit about the varieties of originalisms that are present. And there's been a couple of articles written in the last 3 or 4 years that really draw attention to that. In fact, because of, not only have we been very poor as a judiciary in reflecting those different kinds of originalism, we've almost said it's not there. There's a motor vehicle reference case that says, oh, we don't do originalism. Or Justice Binney often said, oh, originalism is not a part of the way Canadian law puts our interpretive tradition together. But then when you look at cases that might be structurally articulated, or textual deference to language pieces, or some compact theories of confederation that every once in a while leak through. And of course, Aboriginal peoples, that whole area of law is just rife with a really sour originalism to me. We need more conversation about this, because right now we're saying we're not doing it, when in fact we are doing it. And so let's, as some of my colleagues are trying to suggest, let's point that out and then wrestle with this more fully, and not pretend that there's not some kind of a prioricity animating the way we're proceeding. So good question, John.
And would it be a violation of, like, would there be conflicts around precedent to have a case that decided to alter or adjust which originalism they're prescribing to?
Well, see, that's the point, that there's no real way to choose between originalisms. Why should one version be more preferable than another version, and then choose between originalisms and other modes of constitutional interpretation? Because the Constitution itself doesn't say thou shalt use this mode of interpretation. And so we don't have an answer to that question. But I think to call it out, make us mindful of what is actually being done, will at least give us greater tools. And again, my biggest point is about enhancing agency. Like, that's, I guess, why I'm just in this exercise with you all, is because I want to find ways that we can be more respectful, engaged, participatory, democratic, liberty enhancing. Those things are going to likely be more possible if we are aware of what we're doing, as opposed to just being implicit with it and maybe blinded by our assumptions, when our assumptions don't actually bear out in the way that the cases are being interpreted.
Thank you. Any other questions? Good question so far, though. So it's any other final questions? Oh, okay. Well, we'll take that as an ending. That's good timing. Before I let everyone go, let me just extend my thanks on behalf of the Runnymede Society to Professor Burrows for his time today. Really insightful talk. It's given us a lot to think about, and I'm genuinely hopeful that these kind of conversations continue as we start to puzzle through these sorts of issues. Very important issues. I'm just going to remind everyone, if you want to continue these sorts of conversations, please feel free to visit us at the runnymedesociety.ca and check out our upcoming events in our March conference, where we're going to be talking about these issues. And of course, thank you to our University of Victoria chapter for organizing this event today. And Professor Burrows, thank you again for your time.
Aichka, thank you, everyone. Miigwech, and look forward to being in person one day with you all and crossing paths. All the best.
All the best, everyone. Have a good day.
Okay, bye.
Bye.